Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you this 17th day of August. As you know, we do this every Saturday at 3 p.m., even when I'm on location in the Mediterranean. And guys, that was kind of tough because I had to actually do the last two broadcasts at like midnight and 1 a.m. in the morning. For the record, the name of the song you were hearing was When You Say Nothing at All by Alison Krauss. Tune I've liked for many, many years. She's a wonderful singer. I did want to alert you to an upcoming event. It's this week, August 22nd, at the Long Beach Convention Center. The Apartment Owners Association is having a trade show. It's starting basically with the first seminar at 7:30 in the morning, but I think the trade show opens up at 8:30. And admission is free except for the parking. You guys, if you want to learn how to operate your buildings more efficiently, get yourself some vendors that will definitely be better than the vendors you're having. And you can interview them because there'll be a bunch of booths set up, and I'll have my own booth. You guys can come over and ask me questions. There'll be speakers throughout the whole day. So you'll learn other issues dealing with law, but also there'll be issues dealing with wills and trusts and all types of subjects, all about how to operate your building, your business in a more efficient and economic fashion. I will be speaking at 1:15 it's called Seminar Room A. That's the main one that's right by my booth, I might add. And if you do come up to the booth, I have a lot of people who ask me to take selfies, and I'm happy to do that. The topic that I'm going to be talking about today, which is also going to be much more involved at the show, is entitled Landlording 101. So what do I mean by that? It means that there's some basic rules to being a landlord, to being an income property owner. And God knows if you don't follow these rules, you're going to find yourself in a heap of legal trouble and also maybe even financial trouble with regard to tenants coming after you. So I think what you need to know is the basics. And I'm going to go over those real quick in the next 15 minutes or so. And you can see exactly what you need to do on a basic level to make sure that you're going to have a smooth running business. And we are in a business, ladies and gentlemen. We're in the income property business, and we provide a wonderful and a valuable service, which is the providing of housing accommodations. So what do we need to know as we start this? Well, the first thing is you need to know the laws for your jurisdiction. If you don't know the laws for the jurisdiction in which your property is located, it's basically like driving blind. You just don't know. And what you assume is not necessarily. So you need to reach out to either legal professionals or other landlord or the Apartment Owners Association group, and you need to find out what's the laws for your jurisdiction. This is invaluable. For example, I had a client who bought a duplex, and I've used this story before, but they bought a duplex by USC. They wanted to put their daughter into one of those units, and that's the reason why they bought it. They checked out everything about the duplex, the foundation, the roof, everything was wonderful. And of course, they were both occupied, but they didn't think that there'd be any problem in terms of evicting these people. They had learned a little bit about the relocation money that they had to pay, and they were willing to pay it. But what they didn't understand and what they didn't get the information was that the people who were occupying the property had been occupying the property for over 10 years, and each one of them was over 62. Well, that makes it exempt from a landlord moving in a relative or himself into that unit. So basically, the entire reason why he bought this duplex was based on a fact that he could not actually put his daughter in. So the whole purpose was frustrated. And now he's got a duplex, which is basically providing some income, but certainly not what he wanted. And that's because he didn't do his homework. So first thing you need to know is what is the jurisdictional laws for the area upon which your property is located. I do want to share the screen now briefly. And by the way, this is on my website. I do want you to take a look at this. And let's see here. Okay, and I think we can kind of see this. Let me see if I can make it a little bit bigger. If you look at this chart that I have up here, you can see the different jurisdictions in terms of what you even have to do if a tenant's not paying the rent or is violating some other term on their rental agreement. And by the way, this chart is in my website under the free form section. Of course, the website is evict123.com. So you have to take a look and say, you know what, if my property is in Cudahy and I'm serving, for example, that would be right here, ladies and gentlemen, and I'm serving a notice to pay the rent or quit, well, you know what? I've got to send a copy of that notice and the proof of service to the city of Cudahy at this address. So this is an invaluable chart when you're serving any kind of a notice of termination on your tenant. So again, view that on my website. It will give you some insight and stop you from potentially losing a case. The next thing you should know as Landlording 101 is that you do want to perform a credit check and have an application drawn by each adult who's moving into the unit. If they say, well, you know what, I don't want my wife to do it, I just want to do it on my own credit, your response is, no, I'm not going to do that. Each adult who's moving into your unit must be have an application, and you must run an individual credit check on them. Now, sometimes, and I just heard this today from one of my clients, that the tenant came to them with their own credit report. And they say, you don't have to go through the expense. Here's a valid credit report. I just ran it. If the tenant gives you that report, just immediately rip it up, throw it in a garbage can, because you don't know how it was gerrymandered, how it was maybe photoshopped, and you want to run your own credit report every single time. In the case for today, the client had accepted the tenant's credit report. The tenant paid with a check for the security deposit and also for the first month's rent. It bounced. It took us 3-4 months. He was calling me up to tell me that the tenant had vacated after all this time, but he literally got zero money. So you want to make sure that if he had run a credit check, his own, he would have seen that this guy had bad credit. The next thing you're doing as in the situation of Landlording 101 is you want to make sure that you have a rental agreement. The AOA rental agreement is great. I have one on my website that I think is excellent. And you want to make sure that each adult who's moving into the unit must sign the rental agreement. Make sure that you have them sign it first. Don't you sign it and hand it to them, because they'll run off with your signature and you don't have theirs. So make sure that each person who's going to be moving into your unit signs that rental agreement if he's an adult. If there's minor children, you want to list the names of those children as occupants and their date of birth, so you know exactly all the people who are authorized to live into your unit. Please do not have a cosigner. Cosigners are worthless. Another question today was somebody was asking me about a cosigner, and they said one person lived in Arizona, the other person lived in Florida. You don't want to go chasing after somebody who lives in a different state. So cosigners are worthless. If the person who's moving into your unit does not have sufficient credit, then I wouldn't rent to them. At the very minimum, if the cosigner is local, then I wouldn't call him a cosigner. I'd make him a tenant. This way, he can be the subject of an eviction case. Otherwise, you'd have to file a separate civil lawsuit against the cosigner. Okay, make sure that you get all of your money, that is the deposits and the first month's rent. Make sure that you that the check cleared prior to allowing the tenant possession of the premises. If the client today had done that, he wouldn't have had to go through this amazing loss of rent. And by the way, the client told me that these tenants who didn't pay a penny were so abusive and so noisy that the other tenant, this was a duplex, moved out. So he literally cost him the entire income because he didn't follow these words of wisdom, which means make sure that the check clears prior to allowing the tenant in possession. I've said it before that you can even have a counterfeit cashier's check, which we've seen now. So that check has got to clear before you allow him possession of the property. You do know that under the new rules that you can only get a 1 month's rent. This is criminal by our state legislature as a security deposit equal only to 1 month's rent. The exception would be if you have a total of 4 units in a total of 2 buildings, then you can get a 2-month security deposit. Otherwise, you're limited to 1 month's rent. If you do have a fourplex and then you also own a duplex, you can get around this rule by putting the fourplex in an LLC. By doing so, then the LLC only has 4 units. Your individual name for the duplex only has 2 units, so you can get a double security deposit for each of those. Okay, let's move on. When you have a tenant in possession, you want to make sure that all repair requests, except for emergencies, are supposed to be done in writing. That term should be in your rental agreement. I know it's in mine. If it's not in your rental agreement, and assuming the tenant is currently on a month-to-month, I have a change of terms of tenancy on my website where you can demand that all repair requests are in writing, so that this way you have a record when the tenant goes into court and says, you know, I asked him to fix all this stuff. And of course, your position is, well, he never asked me to fix anything. But at least this way, if you're forcing him to put it in writing, we can show how the tenant really never made that request. So make sure that that term is in your rental agreement, or if you already have an existing tenant and it's not there, then make sure that you want to serve that notice of change of tenancy that's on my website, demanding that from this point forward, all repair requests are in writing. You can also make it that it's an email if you do communicate with your tenant in email. Now, we get all these landlords that are getting sued for habitability issues, left and right. The tenants always bring this stuff. The landlord was a slumlord. He didn't do anything for us. We lived in these conditions. And of course, the landlord's just shocked by this. And the way to get around this is to document every interaction you have with the tenant, every single interaction. So if the tenant asks you to fix something, send them a letter saying, you know, you asked me to fix this on this date. I completed the repair on this current date, and put that in your files. Either email it to them or send it to them. Anytime there's a situation where you wanted to gain access to your property, and the tenant refused. Maybe they're claiming there's a pest problem. So you call the pest control company, you tell them that they're coming, and he refused, even if you serve proper notice. You want to document that. You want to say, hey, you know what? You were claiming about a problem. We served you proper notice. You said it was inconvenient and you wanted us to come back 30 days. Well, this way, every single interaction, even the nicest tenants, you have no idea, ladies and gentlemen, how these landlords are getting sued if you haven't been already sued. And this is one of the reasons why we're losing our insurance on the buildings for these baseless garbage lawsuits by these disreputable attorneys. You know, and while I think about it, it's only 99% of the attorneys that give the rest of us a bad name. Now think about that. But in any event, you want to make sure that you document everything in writing as to every interaction with your tenant. Keep that file. That will be invaluable when the tenant tries to sue you, that you have these wonderful records. Also, ladies and gentlemen, if a tenant has the necessity of a legitimate repair, don't wait till tomorrow. Don't wait until next week. We are landlords. We are vilified in the media. We're vilified in the courts. We're vilified by everybody, including the current nominee for the Democratic Party for our president. We're vilified. We're rent gougers. So we want to make sure that we look like the white knights. We want to make sure that we do all repair requests immediately, the same day if you can do it. What difference does it make if you're going to pay the plumber next week? It doesn't make any difference to you. Get the plumber there the same day or the following day. Also, make sure, and I've talked about this on a previous telecast, that if there's any kind of a change of ownership or management, I have that form again on our website. Make sure you serve that form. If you don't, technically speaking, you can easily lose a case. And last but not least, don't wait to take legal action when a tenant is violating the terms of the contract. If the tenant is doing a substantial breach, don't sit there and give in to them. It's only going to get worse. These are the tenants that will therefore push the envelope. They'll be calling their attorneys. They'll be fighting with you. The second the tenant is doing something wrong, ladies and gentlemen, you need to immediately take action. And with that, I am going to move on to our people who have questions to ask. I appreciate everybody there. We're going to go in order of which I see them. And the first one I'm going to ask to unmute is Amarino. I'm going to ask you to unmute yourself.
Hello. I have a question that I want to ask. That's for a cousin of mine, and it deals with the city of San Francisco. Can I ask it, or I'm not sure if you're familiar with it?
I'm not familiar with San Francisco has their own rent control statute.
Right.
So I can answer a general question on standard state landlord tenant law. Is this a house or an apartment? What is it?
The house. And the issue.
Single family home with only one house on the lot.
Correct. Yes.
And what's the issue?
So the issue is apparently my cousin's grandmother had rented this house to an individual, and I guess he went in, paid everything looked good. He continued paying for a few months and then completely stopped. And what had happened after that, I think this was during like COVID. He told me it was about at least 3 years ago, potentially 4, and he stopped paying. And then after that, he just couldn't get the guy. His grandmother, I guess she's just having issues with their memory. She apparently let the guy in without a contract and whatnot. And right now they try to get this. They're dealing with a lawyer, and I guess they're having a bad experience with them. And I just wanted to know, just from the information that I gave you, so he everything was good. He started paying, paid the deposits, I guess, and then eventually stopped paying within a few months after that. And they can't get the guy out since then.
Okay,
So
well, first of all, let me
Mhm.
slow you down. First of all, obviously, no matter what jurisdiction you're in, if a tenant stops paying the rent, as long as you're following the proper procedures for that jurisdiction, I gave you the chart for all the ones in Southern California area. As long as you're following the procedures, you shouldn't have any difficulty in evicting a tenant who hasn't paid rent for months. Now, the issue is, where'd you get this attorney? These cases are so procedural that if you don't hire an attorney that deals just in landlord tenant law, you're really going to be on the shy side. So I know the Apartment Owners Association has an attorney. I don't really remember his name, but if you go to the AOA USA website and you look for their vendors, pick that attorney who's up in the San Francisco area, or an attorney who you know just handles unlawful detainers, and you'll have a much easier time getting them out. So if you don't think this attorney has the proper experience, then what you want to do is get yourself an attorney who does. Anyway, thank you very much. We're going to move on to Tony C. I'm going to ask you to unmute yourself, please.
Dennis, thank you for taking my call. And to be honest, at 1 o'clock in the morning in a cruise doing a Zoom meeting, I gotta take my hat off to you and to your wife also for letting you do all these things on vacation.
Thank you very much. I just didn't want to lose the opportunity, because I really have so much fun doing this. And also, I think it's such a valuable tool to give back to the community. You know, I've made a living and supported my family very well based on this area of law. And it's at this stage of my career, it's really my time to give it back to you.
Thank you. I got 2 quick questions, Dennis. My first question is, does the unincorporated area of Los Angeles, do they have the rent threshold or just the city?
Unincorporated area of Los Angeles does have its own rent control. You do have to register your units with the County of Los Angeles. Actually, it's on that chart there, their address, if you go to my website. And you do also have to post notices on the property, just like you do for the city of LA. And their rent control statute, in my opinion, is even worse than the city of Los Angeles.
The reason that I ask you, because I have posted notices in all my rentals in city of LA, but not in this particular duplex. In this particular property, I have a tenant, well, a roommate that just was added, and he moved in July 16. I did a addendum to the rental agreement for additional tenants from the AOA forms. I didn't ask them to sign the the original rental agreement, but he signed the addendum, and I gave copies of the original rental agreement with the other 3 tenants. And this guy is a wacko. He's giving me so much trouble. You know, he's texting me at 8 o'clock in the morning. He's like 8 o'clock in the evening. Now he wants the room to be painted. He has moved in 2 months ago.
Okay, well, I mean,
And,
okay, let me slow you down, Tony. With regard to paint, if paint is chipping or peeling, then it is your responsibility to paint the unit. But other than that, you have no obligation to do so, and I would be right up front with them. So if it's a legitimate repair request, and again, document all this, then you should do it immediately. But if it's not, and it's something just cosmetic, then there's no obligation on your part to do so.
all right, that sounds good. Thank you so much.
Yeah, before you go, I want to share my screen with you one more time, ladies and gentlemen.
Sure.
And let's see, I think it's this one right here. Share. Okay, so this is my website. And here, if I go here, this is the homepage of my website, everybody. And if you go right there where it says free landlord tenant forms, this is where you would get a notice to pay rent or quit. I've got the change of ownership here on the bottom. But you'll notice here, and this is the special requirements for all these municipalities is right there. But you'll notice that here for the city of Los Angeles, these notices have to be posted. If it's for under RSO, it's this notice. If it's not under RSO, then it would be this notice. For you, Tony, this is the notice for unincorporated areas of LA County. I'm going to open that up, and that's the form that needs to be posted for your property. So everybody meander over to my free form section, and you'll be able to be up on all the laws. Anyway, thank you very much, Tony. I am moving on to M. Brosor. I'm going to ask you to unmute yourself. Go ahead.
Can you hear me?
I can, and I can also
Hey,
see.
how you doing, Dennis? Thank you for having us and doing this like you do always. We really appreciate that. Previously, about maybe 4 or 5 weeks ago, I was in with you, and I have a property outside of LA in Silmar, and it's a single family home. I gave the tenant a 90-day notice to rent increase. I did all the paperwork that was needed. I even got the comps when I approached them on it. Now, my question is, his new rent increase is in October. Should I, one of the questions that I have, should I give him a notice or change of terms for tenancy? I just want to protect myself in case this guy wants to get a lawyer. You know,
Well, a change of terms of tenancy, you've already done that. Your 90-day notice to increase rent is in fact a change of terms of tenancy. First of all, is this a house or an apartment? What is it?
Yes, it's a house. It's a single family home.
With only one house on the lot.
With only one house on the lot.
So, you did increase the rent, I presume, over 90%. I mean, excuse me, over 10%. So therefore you needed a 90-day notice. So you're fine.
Yes, sir.
And
yes, sir.
Don't forget, there's a mailing rule. So if you mailed it, you had to allow for an additional 5 days. So that would have been 95 days.
Yeah, I gave him actually 106 days. And I register, I gave it to him live. But now I was listening to you a while back, and it just popped up in my mind the other day. That civil code section that you quoted, 827, where you tell them that if they are going to hire a lawyer or something, that you're you know, you're not gonna pay more than $500 for the attorney.
Right, now you should check your rental, well, do you have a rental agreement?
Well, yeah, it was a lease.
Okay, and does
it-
the rental agreement limit the attorney's fees? Because most of them do.
I don't quite, I have to double check it
Yeah,
because,
it's just go check that. Almost all of them state that the prevailing party is entitled to reasonable attorney's fees not to exceed $500. If it just says reasonable attorney's fees, then you should use my form that's on the website to limit attorney's fees, and that's the way it's listed.
yeah, and that's what I was thinking about, that you have mentioned it. And I say, you know, because like you said, there's so many attorneys that are going after the landlords for any little thing. I wonder if this, when they see that no more than $500, that deters them from even, you know, representing.
Exactly. It does have some effect, but a lot of attorneys take it anyway. With that, I'm going to say goodbye, and we're going to move over to Jim Polina. I'm going to ask you to unmute yourself, young sir.
Dennis, you made me laugh with your attorney jokes.
Oh,
I
you
was
like
laughing
that one?
hard. I did.
Yeah. I
Okay.
hope everybody caught it, so.
Okay, so I have another question regarding the no jury trial clause inside the rental agreement.
Yes.
I looked it up with your AI and other AI tools. It basically says that it's not fair to the tenant because the landlord, in essence, use extortion against the tenant. So the tenant may not want to sign it, but yet he feels he has to because he wants to rent. So later on, I read that it said, as long as you have a separate agreement, not inside the lease, but a separate no jury clause or arbitration clause, any kind of mediation clause that's separate, that is enforceable. What's your take?
My take is that that's false. The California Constitution ensures that every litigant has the right to request a jury. That's why we're stuck with this. So putting it into a different contract and make him sign it doesn't change anything. This is constitutional law, and there's no way around it, unfortunately. I wish there was, because the delays that can occur when a tenant asks for a jury trial, and of course, they're doing it for one purpose only. And the judges just go along with it. They lean over backwards to give tenants additional time or for continuances. And yet they know that the only reason why they requested the jury trial was just to delay the proceedings. I see that Esmeralda is telling us that Article 1 of the state constitution is where it's listed that every litigant has that right. Anyway, thank you very much, Jim. You have a good week. And I'm moving on to Sonia Ramirez. Hello.
Hi, Dennis. Thank you for taking my call.
No problem.
So I've been doing this for some years. I'm actually a ground up developer within the city of LA mostly. Just acquired a duplex right outside of Beverly Hills. It's RSO. Did use your form for change of ownership. Thank you so much. And was in negotiations with the tenants for move out during escrow. They decided to wait until the new owner, took possession. Now I kind of want to have more, arrows in my quiver. The top tenant is the upstairs tenant has a dog that's not on the lease. The downstairs tenant at this point just started requesting some repairs, and we wanted to turn this into a 3-bedroom, 2-bath. So we need to do extensive renovations to the units, including new electrical and plumbing.
Well, let me slow you down there. Under RSO, substantial renovation is not a ground to evict, period.
Yeah, and that's what I was afraid of. So we were going to go the tenant habitability.
That again
Right.
doesn't help you, young lady. Tenant habitability means that if you need to do repairs that require the tenants to temporarily vacate, that you apply, and it has to be for more than 30 days, you apply to the city for what they call a THP, a tenant habitability plan. But that doesn't really help you. That just means that you're going to have to pay the tenant relocation, and then after the work is done, the tenant can come back. Do you plan to change this duplex into just a single family home? What are you planning on doing?
No, we were planning on changing both units to 3-bedroom, 2-bath, and adding an ADU on the detached garage that's in the back.
Okay, so the only thing that you can conceivably do is to enter into a voluntary vacate agreement with these tenants. Now, you might want to start with the person that has a dog and see if you can evict based on that, since the rental agreement prohibited dogs. And we might be able to try that one and see what happens. And then maybe during the course of that lawsuit, since the previous owner obviously never objected to it, though the rental agreement is specific that it has to be done with the written consent of the landlord to have a dog. And that's contained in most rental agreements. So, but once that case starts, maybe then you want to throw some money at the tenants so we don't have to test the situation of whether there was a waiver issue or not.
Correct. Now, they have thrown out some numbers that are triple the amount the city requires for relocation.
Okay, let me stop you there. The city doesn't have one notification of what relocation is required. If you're going to have a family member move in, that's a specific amount. If you're going to have a manager move in, that's a specific amount. If you're going to permanently demolish these units, that's a specific amount. But if you're talking about a voluntary vacate agreement, that could be a ticket to Disneyland. I'm going to give you a ticket to Disneyland if you vacate the premises by tomorrow. If they agree to that, that would be a
Private agreement.
a proper contract. If they want 100 million, that would also be a proper contract.
Yeah.
Two of you have to agree on a figure. There is no set figure.
Now, my other question about the, we have it under an LLC. Are we still able to say that one of the owners wants to occupy one of the units,
And
whether
the
it's RSO?
And the answer is no. It has to be an owner with at least 25% ownership. So you'd have to
Okay,
take it out of the LLC, darling.
Okay, which is possible at this point, so no problem.
But again,
Okay.
I mean, that's not a cure-all, because
No,
if in fact you have an owner move in and he has to stay there for at least 2 years, okay? If you move out prior, then you have to offer it back to the original tenant. But in any event, even if he stays there 2 years, you have to re-rent the premises at the same rent as what the previous tenant was paying. So it doesn't really help you, even if you did substantial renovation while he was in that unit. So it doesn't really help you. Now, if you wait 2 years, the owner moves out, you rent it to somebody for the same rate as what that previous tenant was paying. And if that tenant magically stays there a few months, and if that tenant magically vacates, now you're free to rent the unit for market level.
oh, I understand.
And I guess you have to read between the lines on that one.
Yes.
But anyway, thank you very much. We are moving on to Chris Landis. How are you, sir?
Good. Thank you. I'm well, kind of good. Just lost a UG case after 3.5 months. But it seems that it's due to the lawyer. I'm thinking because he didn't
Well, I don't want to discuss specific cases here because that's not what this forum's about. This forum is about general questions, Chris. So if you've got a general question, I'm happy to answer it.
Okay, is it the lawyer's responsibility? Like I lost the case because he filed the 3-day thing with the city before we served the tenant, and then he included
Before he served the tenant with what?
With the notice, the 3-day pay or quitter notice. He filed that with the city before we posted the notice on the door, and then on the notice itself and the UD, he included the utilities, so it got thrown out.
Okay, well, if in fact in a notice to pay rent or quit, okay, and I'm going to end with this, in a notice to pay rent or quit, you can only ask for rent. That's why they don't call it a notice to pay rent and utilities, or a notice to pay rent and refrigerator rental charges. It's a notice to pay rent. So if they included anything else in that, then you are on the shy side, unfortunately. Anyway, we're happy to take the case, and thank you very much, Chris. We're going to move on to, it says here, iPhone 6. If you could say hello.
Hello, Dennis. This is Susan.
Hello.
How are you?
I am fine, thank you.
Good. Well, I'm not calling you as a tenant this time, and my jacuzzi issue got continued again. So I'm calling you as the landlord this time.
I like that better when you call me as a landlord.
Yeah, but I'm learning a lot by being a tenant. Anyway, just got a new tenant in June. I
What
have a lease
city?
in Monterey Park.
Okay, an apartment house, I presume.
It's a house in front and a two 1-bedrooms in the back, and
Okay,
it's 1 bedrooms. So I'm a leasing agent, and she took electronic funds for security deposit and first month's rent. And then she sent me a check from her account, the leasing agent, less the commission. So all good. So then a few weeks later, the leasing agent told me that the electronic funds deposit for the security deposit and first month's rent was reversed out of her account. And so she contacted the tenant, and the tenant said, "Oh, I don't know why." And then she says her account was frozen. Let me pay, do you take credit cards? So the woman said, the leasing agent said, "Well, not usually, but if you want to pay the fee, the 3% fee, yeah." So she took a credit card. So now August 1st was the first month that she was supposed to pay, a separate, her first month's rent. Of course, it came. The rent didn't come. She was going to make a deposit directly at the bank to my account. Contacted her. She said, "Oh, I thought it was today was the 31st. I'll do it tomorrow." Then it was the 1st. Then she sends me a picture of her ankle all swollen, saying that she got a spider bite and she's in so much pain. And
all right,
she's
let me
at work.
slow you here. You're obviously dealing with a thief. Whatever happened between your tenant and your real estate agent, that's not your business. You already got paid, so you just have to be quiet on that one. But you already see the writing on the wall that the person is a thief. So if she hasn't paid August rent, what we should be doing immediately is serving a 3-day notice.
So I served a 3-day notice from your website, and she didn't pay. Contacted your office. They were really terrific. And then we realized I put the wrong date. Okay, I know you've given warnings. I should have you do it, but the 3-day notice. So I did the notice
When you
wrong
say
date.
the wrong date, what date did you put in? What in reference to what?
There's also a part that she was supposed to pay for June 22nd to June 30th that I didn't know about until my leasing agent told me on the August 1st. So I'm sorry, the question is, so I put June 20th to June 30th and August 1st. So but it's supposed to be June
what's wrong
20th.
with that?
I put she owed June 20th to the 30th, but she really owed June 22nd to the 30th.
Okay, so then you probably asked, if your period in the notice is incorrect, though you don't really need to put a period in the notice, even though everybody does, but technically it's not required. But anyway, it's not a big deal. Why run the risk? So let's just serve a new 3-day notice and we'll proceed forward with it.
Well, so what happened was that after I was talking to your office, all of a sudden she texted me and she deposited the money.
Okay, well then that's great. So then what I would do is I would make sure that if you don't have your rent by September 1st, I'd jump on her September 2nd. But anyway, thank you very much. I love your stories. We are moving on to Donna. Donna, I'm going to ask you to unmute yourself. Donna Dandini.
Yes, thank you, Dennis. I appreciate it. So we have a question. I'm here with my husband, Mario. You just spoke to him a little while ago. He had a question regarding our tenant that has that new 90-day notice for the rent that's going to increase October 1, the new rent. If what they normally do is they normally pay us some monies in advance prior to the due date of the 1st of the month for when rent is due. Through Zelle. If they do that when the new rent is due and it's not the full amount of the rent, do we accept it if they Zelled it into our account?
This was Monterey Park?
No, this was Sylmar, actually.
Okay, so first of all, how many bedrooms?
3 bedrooms.
Okay, so for 3 bedrooms, and I don't know what you raised it to, let me pull up my chart here. You can't serve a 3-day notice unless the amount in the 3-day notice is greater than $3,263. So if you take a partial payment, which therefore is going to make it less than $3,263, then I wouldn't take the partial payment. But let's pretend the rent's $4,000 and they paid you $500. I would take it. And then on October 1 or October 2nd, the day after, I would serve a 3-day notice for the balance owed, which would be in that example, 3,500, and that would be above the threshold.
Okay, so what do you want to say to that, Mario? Like, so I'm trying to understand it. So like if the new rent is over $4,000 and they
pay you
31
anything, as long as whatever they pay you, they still have to owe you at least $3,200 and more than $3,263. So if they at least owe more than that figure, it's okay to take the partial payment. But if the partial payment means that it's going to be $3,263 or less, don't take it. And by the way,
take it, right?
pretty clever. You guys got 2 Zoom meetings going on at the same time. I haven't
Okay.
seen that one. You snuck in twice. But I love you. I
Because
love
I'm
you
trying to answer
anyway.
this question for him. Okay, so if it's going to be less than the 3,263, don't take it. But if it's going to be 3,263 or greater, take it. And then
No, greater than 3,263.
greater than 3,263, accept it.
All right. And with
And then
that, we are moving on, young lady. Let's go to Eric S. I'm going to ask you to unmute yourself. I'm trying to get through everybody today. So say hello, Eric. Oh, there you go.
Hi, Dennis. How are you?
I am good, thank you.
Yes, Dennis, I have 2 questions. I spoke with you a few weeks ago about that tenant that I don't know if you remember the conversation we had about we gave some concessions on the rent, so that took the rent down by $800. So it went from 4,000 to 3,200.
What was the
But in our
concessions for, Eric? Because I don't remember the conversation.
it was just for just to get more business, get more tenants to move in.
Okay, so
So
this was a tenant who was moving in where you gave them that concession.
yeah, so the original rent was 4,000. We gave a $800 concession, which took their rent to 3,200. And then for our security deposit, we actually charged the 4,000. I remember you
Yeah,
telling
and
me
I
that.
said I didn't like
Yeah,
that. The way you had
yeah,
structured the contract, I think you should
correct.
have only taken a 1-month security deposit, or at least it had to equal what the actual rent was, not the 4,000 figure.
Yes, and we sent the $800 back to the tenant, and the tenant refuses to take the 800 and said that he's gonna sue us in small claims
Let
for
him sue
overcharging.
you. Let him go sue you. I'm going to sue you too, Eric. I mean, it makes no sense. You're giving him back the money. What is he suing you for? It makes absolutely no sense.
Right. And then the second thing is, I had another case that an attorney worked
And by
on.
the way, if
Dr.
you could
Ahmed,
Zelle him the money, if you know his Zelle account.
I
So
do. I do.
I
I
would
know
just
the deal.
Zelle him the $800 and then you have total proof. Look, we think it's a questionable call, and I still think it's a questionable call, but I always try to be more conservative on these types of issues. So I think it's questionable whether you could charge the 4,000 or not, but here you gave it back to him. So what's your problem, you know?
Right. And then the second issue is that we had a case that we finally was able to get the tenant out after almost a year. And at the time, the attorney told me that something was wrong with the notice, but we still decided to go through with the case and everything, and we won on the case. But now the tenant has filed an appeal to appeal on that defective notice. If we lose on appeal, are we going to be in some type of mess? Like if they
Well,
reverse
I don't.
judgment?
Okay, first of all, the tenant's going to get evicted if he hasn't already been evicted. Is he evicted?
Yes.
Okay, so if the
Yes.
tenant's already evicted, all they can do is he'll win the case per se, and then you'd have to go sue him separately for the judgment for the rent owed. That would be about it. So there's not much to it. But
Okay.
the thing that they could do is they could file. Is the tenant already out, Eric?
Yeah, the tenant was out on the
Okay, then
17th.
that's fine, because sometimes when they file an
Yes.
appeal, what they do is they file a motion called a stay pending an appeal, which means that the tenant gets to stay in the unit while the appeal is going forward. That's kind of a miserable situation, but I wouldn't be too concerned. Just do what you need to do to defend that appeal. And with that, we're going to move on to Cheryl G-Tel. I presume that's your cell phone.
Yeah, well, actually, I'm on my computer. Hi, Dennis. How are you?
I am fine, thank you.
I have another debate between my husband and I. So, I have a unit that actually is it's posted for rent right now, but we did go ahead and it's posted as a month to month to start with, because I remember some time ago you indicated that that's a good way to go. So if
It's a
the
good way to go for a few reasons. Number one is that Section 8 will not accept a month-to-month tenancy. So if you're not into Section 8 tenancies, that's one way. Also, depending on the jurisdiction, like the city of Los Angeles, but not under RSO, if it's month-to-month, you're allowed to ask the tenant to move within the first 6 months. And if you're under statewide rent control, you can ask the tenant to move without cause for the first year. Go ahead.
Okay, so it is in the city of Downey. And I just wanted to find out what your success has been with, because my thought is if I'm asking someone to put that kind of, 1 month's rent for a deposit and to go to the trouble of moving, like if it were me personally, I would not want to sign a month-to-month lease and I'm, making an investment to move. He, on the other hand, is like, hey, that's what the attorney says do, so that's what we're doing. Anyway, it is
Well,
posted
it
as a
is an
month-to-month, but
it is an economic decision. You do have to rent out these units. I
right.
haven't heard any pushback from tenants saying, I don't want to just do a month-to-month tenancy. I haven't heard that from my clients when they do this, and it's common to
Okay.
rent premises on month-to-month.
Okay, all right. So it's being shown today, so we'll see what happens. My second question is, I have a property in Belinda, which is part of La Puente, which is confusing to me, but we have a single family home and we are looking to put an ADU on it. And we want to know, if we do that, will we still be able to raise the rent to whatever we want to raise it to?
Okay, well, first of all, you're talking about for the single family home, not for the ADU.
Yes, for the single family home. So
Okay, so before if you construct an ADU, once you get the certificate of occupancy, that pushes the house under statewide rent control. So you'd be limited to rent increases of 8.9%. But this is really simple. Just raise the rent on the single family home before you get your certificate of occupancy. Then you don't have any issues.
okay, all right, perfect. Sounds good. Thank you so much.
Thank you, Cheryl. Let's see here. Let's move on to Diana D. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Hi. Thank you for showing up during your vacation. That was very kind of you. Dennis, I kind of asked you this question before, but we got off on something else. I have a tenant that is really giving me a hassle. And anyhow, I've raised the rent. The rent was very, very low, and we've raised it a couple of times this year, but I'm doing like $50,000 worth of repairs now. And the property is commercially zoned, so I think I can get much more rent for it. And I'm just kind of concerned on what can they do if they don't consider the rent reasonable? Can they sue us, or what?
Well, this is a single family home, correct?
Single family, city of LA, yes.
Okay, so there is no rent limitations. You can charge whatever you want, and you can't charge rent that would indirectly saying, hey, I really want you out. I'm going to charge you $30,000 every 2 weeks for your rent, because that would look like you're just trying to indirectly ask them to move and you don't really have the right to do so. If you're going to change this into a commercial unit, then we can just ask the tenant to move based on major renovations. You're changing what the type of unit's going to be. So that shouldn't be a problem. But again, you can also raise the rent to whatever you like.
Okay,
You
so
can
they,
justify on the basis that, hey, you know, if I turn this into a commercial place, I could get $5,000. You're only paying me $3,000. So if you want to stay, then I won't change it to commercial. So pay me $5,000. Otherwise, I'm going to ask you to move or pay that amount of rent.
okay, perfect. Thank you so much.
My pleasure. We're moving on to Julia Jordan. How are you?
Hi, Dennis.
Hello, Julia.
We're good. And like everyone says, thank you so much. Congratulations on your 50th wedding anniversary and your trip to Paris and all that. And thanks for taking our calls.
Well, actually, we went to Italy.
Oh,
We went to Greece.
uh-huh.
So we were all over there.
Well, good. You look well rested too, by the way.
Well, I got a little bit of a tan. I usually look so pale on this because I'm not the outdoor guy, but
Okay. So my question is about a 4-unit property that we have in Inglewood. There was a discrepancy on a rent increase that I did. Long story short, we battled it out with the city and we lost. And so the difference is being paid back monthly over a period of a year. Question is, the tenants have come back.
let me slow you there. So the
Okay.
city determined that the rent you were taking was improper and you owe this money back to the tenant, correct?
Yes, so.
And you're not just writing one check, you're taking it a little bit at a time?
Well, they're allowing the tenants to deduct it. It's about $400 a month over a period of a year.
You don't want to just write a check for all the extra money and call it a day?
That's what they did. They calculated it out, and at that point, I just accepted it.
Okay, the problem with that is, and why I wouldn't have accepted that, is if the tenant doesn't pay next month's rent, you got a problem because you actually owe the tenant money. So we'd go into court and lose on a non-payment of rent case. Or even if the tenant brings in a dog or an extra person, it would show that you have actually accepted advanced rent. So I don't like that. If the tenant's fine, doesn't do anything, no problem. He's paying, he's deducting $400 a month. But otherwise, from my standpoint, if you think you're going to have some problems with this tenant, you're going to have to give him back all the money. But go ahead with your question.
Okay, and that's exactly why I'm asking, because they actually wanted a new agreement and it just didn't settle well with me. And I just felt like there was, could be a hidden agenda there. And I was asking you for kind of if that was a good idea, and if not, kind of how should I?
Yeah, no, I would recommend just figuring out exactly what you owe and then give it back. Now, I've got a question for you, young lady.
Okay.
Are you ready?
I'm ready.
How come you don't have your clock set correctly? It says there that it's 2:35, right behind you.
Oh, that one, yeah.
Yeah, you gotta get, you're making me off calendar here.
Okay,
So
well,
please, if you're gonna call me, you gotta have your clock set, okay?
okay, you got it. Thanks.
All right, Julia, nice talking with you. Lynette, how are you?
I am doing good.
Thank you.
I have a single family residence in unincorporated Whittier. I have a very old rental agreement when my dad, they've been there since the 70s, and I'm cleaning it up. So my question is, you say to have all the adults sign it, but the original contract is with the mother. And if she moves out, I don't want her kids. So by them signing it, do I have to allow them to stay?
I think you're
if
gonna
she
have to
moves
allow
out?
them, I think you're gonna have to allow them to stay no matter what, because since the kids moved in with the mother, then they're protected tenants under the county rent control ordinance. But again, it's a single family residence. You have the right to raise the rent to whatever you like, young lady.
Okay. Yeah, because when she moved in, all the kids were underage.
Right, but they have the right to stay because they were
Okay.
original tenants. So, but again, make sure, as I've always said, make sure that your rents are at market level. If they're not,
Yeah, I need to
please.
start raising them.
Oh, immediately. And again, I
Yeah.
quote this on every show, this wonderful website, which they should be paying me because I promote them all the time. And all I do is pay for their service, even though the first 5 times is free. It's called Rent-O-Meter,
Yeah.
RENT-O-Meter. You first 5 are free. You put in your address and the amount of bedrooms, etc., and it'll tell you exactly what other people right near you are charging for their rentals.
Yeah, I'm paying the yearly subscription.
Oh,
Even
you are. So then,
yeah,
then
because I figured he's offering something good, so why take it for free?
and that's what I feel too. I've done services that I've been so impressed. And if they said, well, if you pay us a little more, we can take away the banner or something. And I do it because I just think it's fair.
Right.
Anyway,
So because it's unincorporated, I can raise it whatever I
well,
want.
it's not because
I mean,
it's
within,
unincorporated. It's because it's a single family residence with only
Okay.
one house on the lot. And we don't know what's going to happen at this
In
next
November.
election. We're going to vote no on Proposition 33 because they could do away with the Costa-Hawkins Act. So please, I'd start raising that right this moment. And with that, I'm going to appreciate your question. We are moving on to Garber. I'm going to ask you to unmute yourself.
Thank you, Dennis. I appreciate it. I have several single-family homes, and with regard to the City of Los Angeles rent protection notice, in the past, since there are no common area, I can't hang this thing in a common area because there's no common areas.
Well, you can hang it right by his mailbox. You can put it on his front door, take a picture, let him
Oh,
take it
okay.
down.
And then it does, after that, you don't have to have it.
Well, technically it's supposed to be posted, but hey, I put it up. I took a picture. I don't know what happened to it. That wouldn't be your responsibility at that point.
Okay, so what I did in the past is I gave the tenants the notice, had them initial it and date it. But now it seems like they're going to change these things every 6 months to 12 months. Is it effective if I just give these notices to them through a text? Because
Okay,
that would
first,
leave a track.
The law says it's got to be posted in a conspicuous spot. And it doesn't make any distinction between an apartment house or a condo or a single family residence. So you've got to have it posted, post it, and let them take it down if they don't like looking at it.
Okay, now you said post it on the mailbox, or can I
Post
just
it in a conspicuous spot on the property, wherever
Okay.
that is, young sir.
Okay, thank you very much.
All right. Thank you. Thomas D. We're running out of time here, and I got to go to Costa Mesa for a 75th birthday party, which shows you how old I am if my friends are 75. But notwithstanding, Thomas D., I'm going to ask you to unmute yourself.
Hello, Dennis. Thank you for taking my call. I have to say, I did have a case with you before where you're successful, so I really appreciate the help that you provide. Here's my question. I have a 4-unit apartment in Boyle Heights. It's under RSO. I bought it 3 years ago. We have tenants it came with the tenants, and the leases were written by the prior owner. On the lease, it states that so it has the name. So with 1 unit, I have the 3 tenants listed. And it says that a maximum of 3 tenants should be in the unit, but it does not say that only those tenants shall be in the unit. So 2 of the tenants moved out recently, and the remaining tenant claims that she can bring an extra person and without charging an extra $100, as it said by the under the lease. Because it doesn't state that only those 3 tenants should be the original tenants.
Right. Most rental
the case on.
agreements, most rental agreements do specifically state that the named occupants are such.
Yeah.
But in your rental agreement, it just said, here's other tenants and 3 people can live there, but it doesn't say who. So she can bring in whoever she wants. You have no way of stopping that. And you can't approve or not approve. All you have to do is make sure that you get your rent. With regard to and we're going to call it A, if A moves out, leaving this new tenant behind, you have the right to either evict that tenant because you've never taken rent from this stranger, or you have the right to raise that tenant's rent to market level.
Oh, I'm sorry, I'm confused. One more time.
Okay, so you rent it A, I'll give you the issue. You rent, and I've talked about this in a previous, this is under the Costa-Hawkins bill, which we're hoping is not revoked. But if you rent to A, B, and C leave, and now D comes in, and D is even paying you rent, okay, and you've accepted rent from A, you've accepted rent from D, but now A moves out. The day A moves out, you have the right to raise D's rent to market level.
Okay. Okay, thank you for that. And again, so Chad, that's not the case, but if that gets there, I'll definitely take advantage of that. But again, as far as the lease agreement, it states it has the three tenant names on the old lease, right? Say person A, person B, person C. B and C moved out. And again, the language says extra tenant will be $100, but again,
But it's not an extra tenant, darling.
I know, but that's
It's
the way
not
it's
an extra. You had 3, now you got 2, you got 1 less. So that $100 provision would not work, my friend.
Okay.
All right, let's see. I'm gonna take one more. It's 4 o'clock. And I'm gonna ask Sonia to unmute yourself.
Dennis, hi.
Hello.
Hi. So I'll be quick. My question has to do when the tenants agreed to a repair at a certain date. They let us know that they won't be there, but they have a relative who is a minor, 17, who's going to be there. So if the handyman goes, I'm cautious. Can I have a friend of mine go with them to open the door?
Yeah, I think
and
you should
be
have
there?
I think you should have another person in attendance you'd have a total of 4 eyes who can testify as to what occurred, but I don't see a problem with that.
Okay, thank you.
All right, well, ladies and gentlemen, we have made it through another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday. I do appreciate all the people who participate and all the people who watch on YouTube Live. If you guys could do me a favor, and if you go to the YouTube channel, which is Evict123, you can get it from my website. I'd appreciate if you could subscribe to the channel because it does somewhat help me defray the cost of this. And with that, I'm going to wish everybody a happy weekend, and I think I'm en route to Costa Mesa. Have a good day.